Chairman. I appreciate the hearing we're holding here today, and I'm listening to our witnesses and thinking back at that reauthorization time of the Voting Rights Act back in 2006. And I'd first remark off Mr. Overton's comment, preclearance is a reasonable device. I would think also that voter ID would be a reasonable device. And when I look across the country and try to accumulate problems we might have with elections, I don't know where to go look, and I wouldn't deny that it likely exists in places in the country and probably in smaller areas, much smaller areas than when this act was first passed, but I wouldn't know where to go look to find real voter intimidation and real discrimination. And the first place that comes to mind to me when I utter those words is Philadelphia. So I think there's more damage to the integrity of our election system that comes from lack of voter ID than might come from voter intimidation. And when I think about the discussion about bringing up the Voting Rights Act and perhaps rewriting it, that would mean that the authorization would be also subject. And I question the wisdom of an authorization that would last for more than a generation, 25 years. Thomas Jefferson declared a generation to be 19, in case anybody's quibbling. And so the 25-year reauthorization in 2006 I thought was imprudent. That's one of the reasons I voted against it. I think we need to have a lot more improvement in the integrity of the individual ballot, and I think we know that, but there's a political barrier in the way. I think if we bring up the Voting Rights Act and we have an opportunity then to open it up, I think multilingual ballots become a question. There's no logical reason that ballots should be in anything other than in English. If you take a citizenship test, that's the English. You have to demonstrate proficiency in English. I would ask, turn first to Mr. Adams and ask, if the Voting Rights Act were either allowed to expire or repealed, is there constitutional protection there for the issues that are covered in the VRA? And how would you expect that might be worked?
Well, obviously, somebody can bring a 1983 action under the 15th Amendment, which guarantees the right to vote free of racial discrimination. But, of course, Section 2 also incorporates those concepts. You know, you mentioned voter intimidation. Just last week, a state judge in Mississippi determined in a ruling throughout the results of an election because of voter intimidation by a political operative working for somebody named Rodriguez Brown. This is a proven case of voter intimidation. Will anybody do anything about it? Will there be a federal case brought? Somehow I suspect not.
Thank you, Mr. Adams. And so, also, if I remember Mr. Von Spakovsky's statement to the extent that African-American voter turnout's actually higher in the non-covered districts than in the covered districts. Did I hear that correctly? And would you elaborate a little bit?
Black turnout is better in what were covered jurisdictions than non-covered jurisdictions around the country. In fact, consistently so. Like I said, the Table 5, which is a map from the census report in May, is really dramatic. I mean, it shows black outvoting whites largely in the covered states.
And then could you explain why that is?
I'm sorry?
Can you explain why that is?
Well, one of the reasons, I think, is because of Section 5 and the Voting Rights Act, and because the kind of systematic discrimination you had in 1965 has virtually disappeared. And if I can make a point here, you know, people keep saying, well, with this gone, these jurisdictions are going to return to acting that way. Well, that ignores a very important point. In 1965, there were no black elected officials in the covered states. That is not true today. In fact, all the statistics and the court findings show that those covered states have a much larger number of black elected officials than other parts of the country. That's true in states like Georgia and Mississippi, and the idea that those officials are themselves going to start discriminating or put up with that kind of discrimination is just, that's just not a reality.
Okay, but what you've said, I think, is that the Voting Rights Act has worked in these covered districts, and it's brought the black turnout up a little higher than it is in the non-covered districts. So does that imply that there's discrimination in the non-covered districts, or how would you explain the statistical variance?
Well, we know there's discrimination in uncovered jurisdictions because there are Section 2 lawsuits that are filed, as Mr. Adams pointed out, in places like, was it Euclid, Ohio, and other areas. You know, disparity in turnout between different races isn't always due to discrimination. I mean, sometimes just people not being interested in particular candidates. I think Ms. Lee, you know, talked about the cyclical nature of elections. But the point is that if Congress is going to have Section 5 coverage based on the Section 4 formula of low turnout, then there are many other places in the country that have never been covered under Section 5 that ought to be covered in any new version of this law.
Thank you. I just ask unanimous consent to ask an additional question, if the chair would indulge me.
Without objection.
Thank you, and I thank the members of the committee for allowing that. I was very interested in what I heard Mr. von Spakovsky say about apartheid redistricting, and I don't know that that's going to be revisited in this hearing if I don't bring it up. I come from a state that has anything but that. We have statutory directive that, without going through the definitions of the language, it essentially prohibits the gerrymandering by race or by party. And we end up with, I think, logical districts that are compact and contiguous. And from that perspective, I see the gerrymandering that Mr. von Spakovsky has brought up in this hearing. And myself, I would recommend looking at that other states drawing districts like that without regard to race, ethnicity, the residency of any incumbency, and logical, compact, contiguous. And so I'd ask Hans if he would speak to that, just elaborate a little bit more for the benefit of the committee, please.
Look, I don't think it's a good idea when you take cities, for example, where the residents, no matter what their race, have similar interests, similar public policy problems, and you divide them up into differing districts just based on race so that particular individuals of particular races can get elected. I mean, that leads to many different problems. It does not help integration. It does not help bring us together, which is what the Voting Rights Act was intended to do. But, you know, to be quite frank, politicians like it because it produces very safe districts for them where they don't get competition. And I don't think that's a good thing. You know, so some of the witnesses here may agree with me that they don't think that's a good thing. And that is the direct result of Section 5 and the way it is administered by the U.S. Justice Department.
Thank you very much. I thank all the witnesses and yield back the balance of my time, Mr. Chairman.